Has everyone had a relatively okay week? Relatively?
I don't even know what that means at this point.
By comparison to, the entire year?
It's been really hot here in DC. I don't know.
It has been.
Yeah.
My mom sent a message in our group message, and she was like, Houston, Texas is actually the coolest today. They have family here in DC and then in St. Louis. And I was like, I thought I left this heat in the South when I came up here. Okay, I guess if people are joining right now, I'm assuming they are. Do we need to give them some time? Are we good? Okay, awesome. Well, good afternoon, everyone. Thank you so much for tuning in today's event. It is Holding Court, Supreme Court Term Review, Church, State, and the Shifting Court. My name is Jamaal Lockings. I'm a Dorot Fellow at the Alliance for Justice, an association of nearly 140 member organizations committed to building power, transforming courts, and securing justice for all. I'm looking forward to today's conversation and a chance to dive into the Supreme Court term because just like the president and Congress, the court shapes nearly every part of our lives, and raising awareness about its decisions is a passion of mine. So today's conversation is part of our ongoing series, Holding Court, Justice Conversations with AFJ. This series features leading activists, authors, scholars, and attorneys discussing current political and social justice issues. The Supreme Court will be wrapping up its 2024-2025 term in the next few days, well, tomorrow. And while we're still waiting on some decisions, the conservative majority has drastically reshaped and eroded civil rights, trans rights, disability rights, and more. In particular, many of the cases on the court's docket this year highlighted an ongoing shift in how the justices balance compelling claims of religious liberty, anti-discrimination protections, and government neutrality. We will be diving into this topic with our expert panelists. First up, joining us today is Chris Geidner. Chris is an award-winning journalist who has been writing and reporting for nearly 25 years. He is the publisher and author of Law Dork, a Substack with over 70,000 subscribers. I happen to be one of them, where he reports on the Supreme Court and more. You may have also seen Chris's work in BuzzFeed News, the New York Times, CNN, and MSNBC. Also on our panel today is Dena Sher, the Associate Vice President for Public Policy at Americans United for Separation of Church and State, where she helps direct AU's state and federal legislative and policy work. She's an expert on religion law and focuses on its intersection with reproductive rights and healthcare, civil rights, LGBTQ+ rights, and education. And last but certainly not least, we are also excited to have Alison Gill joining us today. Alison is the Director of Nominations and Democracy for the National Women's Law Center, where she leads and manages the Law Center's work on strategies concerning judicial and executive nominations. Prior to her work with the Law Center, Alison served as Vice President for Legal and Policy for American Atheists, where she managed the organization's litigation activities to protect the separation of religion and government. Dena, Alison, and Chris, thank you so much for joining us today to analyze this Supreme Court term. Later in the discussion, there will be an opportunity for the audience to ask questions. Please submit your questions in the comment box on the platform where you are watching. Please note, AFJ staff members will be monitoring the comments, and any comments that are not in line with our mission or are discriminatory will be deleted. Now, let's get started. Let's start with the big picture here this term. Within the First Amendment, there are two clauses related to religion. There's the Establishment Clause and the Free Exercise Clause. The Establishment Clause prevents the government from establishing a religion, and this clause is often what is associated when people are discussing separation of church and state. The Free Exercise Clause allows individuals to practice whatever religion they believe in, with the caveat that there can be restrictions if it infringes upon others' rights. So, I want to ask our panelists, from your perspective, how do you see the Supreme Court reshaping its interpretation of the First Amendment's religion clauses, and what does this term tell us about where things are headed?
Yeah, I mean, I'll just start off with sort of both the easiest one and maybe the most frightening one, which was the decision that wasn't a decision. We had a case that was looked at as the potential for the Supreme Court okaying the first religious charter school in the country out of Oklahoma. And although we had arguments, we had all of this briefing, it turned out that because Justice Barrett had recused herself from the case, the court split 4-4. We don't know what the vote was, which one of the Republican appointees, presumably only one of them, joined with presumably the 3 Democratic appointees. But the fact of the matter is that the 4-4 result essentially told us that if there's a case that Justice Barrett won't be recused from, she is going to have the tiebreak vote on the question of whether or not that balance of the First Amendment that you talked about is a balance at all. And that was essentially at arguments the question that Justice Sotomayor had raised, whether or not the Free Exercise Clause would essentially just supplant the Establishment Clause, and the Establishment Clause would really have no force anymore.
Just to pick up on that, in the broader context for the last several years, we've seen the Supreme Court has really flipped the religion clauses on their head in many ways. They basically written the Establishment Clause out of the Constitution in some ways, or subordinated it to the Free Exercise Clause when that applies. And meanwhile, the Free Exercise Clause has been expanded significantly through exceptions to Employment Division v. Smith, through expansion of what counts as animus or discrimination against religion, through an especially stringent application of strict scrutiny, and just as special standing considerations that's given over and over again to religious plaintiffs against the government. There's just been a lot of solicitude for religious plaintiffs. And, I think that makes a huge difference in how we should think about these religion clauses and how they'll be applied in future cases.
Yeah, I mean, I think that none of the arguments that were made in the 3 religion law cases were surprising, right? It's the same kind of arguments that people have been making for years, essentially trying to use the Free Exercise Clause to require the government to act, to either accommodate, to opt out, or even directly support people's organizations' religious beliefs. The one thing that I will note, though, is that in the 2 cases that have been decided so far, which we can get to a quick summary of, the pace of those arguments and what they've been able to accomplish seem to slow down just a little bit. So, that's probably one of the most interesting things about these 2 cases so far.
With the important caveat of so far, because we'll see what we get tomorrow.
Yeah.
Yeah.
Do we want to discuss, maybe want to give a quick summary of the Wisconsin Catholic Charities v. Wisconsin case, which is the other case that's been decided so far. There, the Supreme Court ruled in favor of a religiously affiliated organization that sought an exemption from Wisconsin's unemployment tax system. The law exempted churches and church-related organizations that were operated primarily for religious purposes. Justice Sotomayor wrote a unanimous decision that was kind of narrow, and it addressed how the Wisconsin Supreme Court had applied the state law, rather than making a judgment on kind of the interpretation of the law overall. And then the other thing to note is that she reaffirmed really important Establishment Clause principles in the decision. So again, pace slowing down just a little.
Yeah, I go ahead, Alison.
Okay, I was just going to say that it was great to see the Establishment Clause still has some life, frankly, and also that Justice Sotomayor relied on early Establishment Clause precedents like Epperson and reiterated those and relied on them to show that they still had valid life from the majority of the court, which is excellent news in my mind. But it's also worth noting that Justice Thomas, I believe, had a concurrence saying, we didn't really need the Establishment Clause here at all. We could have just done this under free exercise. So it's interesting in that respect. I'm sorry, Chris, did you want to add?
No, I was essentially going to say something very similar. I think that the idea that having, particularly given the reality of what Justice Sotomayor, along with Justice Kagan and Justice Jackson, are facing, it is really interesting when we get majority decisions from one of the Democratic appointees, particularly in a case like this, because since it was unanimous, we know that means that the chief gave the opinion to Justice Sotomayor, and that unlike when Alito gets a majority opinion, sometimes she didn't lose it by writing too strident of an opinion, but she did still sort of highlight this as a religious neutrality case, not what we've seen in the decisions from the conservative justices being more of a religious supremacy case. That she just kept reiterating the point that, like, the reason why this is a problem is how it's applied, that it's hurting Catholics, but wouldn't hurt this person, wouldn't hurt this person. And I think that it's just, when we talk about like different actors playing different roles in a system, that having the three of those justices able to play a role like that when a case like this comes up really can change what the law is for now.
I have to say, I do still have some concerns. I mean, I think the case was well and rightly decided. I do still have some concerns that the other side's going to try to read this as broadly as possible to say that the government can never make distinctions based on religious activities versus secular activities. So, I mean, I think it was very clear and distinct, and that's not the decision. But because the Supreme Court in Wisconsin applied this strange test that doesn't usually, like, it's just an interesting and unique scenario, right?
Yeah, no, it was a way for, in the decision, kind of reiterate these Establishment Clause principles that we can't favor one denomination or one religious set of religious beliefs over another set of religious beliefs. So that's where she had the opportunity to reinforce these historic, really important, longstanding Establishment Clause cases. But I agree with Alison. There is, because it was so narrow and just said that the application here was bad, it didn't lay out a future test. And the advocates on the other side pushed very hard for religious motivation to be the sole determining factor for whether someone gets a religious exemption from the unemployment tax. Well, that's basically I get to have the exemption if I say so test. And it cuts out the role, the traditional role for courts to apply objective analysis and look at objective factors to decide who gets religious exemptions. And so it doesn't foreclose those arguments. We know they're going to come. They've been coming in all sorts of other religion law issue areas. For instance, whether or not religious employers get to say that some of their employees qualify as ministers under the ministerial exemption, right? It's the same thing. Like, I get to say so rather than looking at what these individuals actually do in their jobs. So that's troubling. And the potential broadening of the exemption then is also troubling, because more and more people won't be covered by these really important employment protections in their workplace.
Yeah, and I wanted to just get y'all to expand on the idea that while it is super important for, Justice Sotomayor and the liberal justices to write these opinions and to write them as narrow as possible to help the rule of law for now, I wanted y'all to dive a little bit more into why it's so important to be, I guess, mindful of these opinions, because a lot of this, it does happen over time, and then all of a sudden you have this watershed moment. And I feel like it's been religious liberty litigants have been, attacking all sectors, right? And it's just like chipping away at several different pieces every term. And so it almost feels like it will eventually lead up to something. And so how helpful is it to kind of, have these narrow rulings when we say things like, yes, they're going to read it as broadly as possible?
I mean, I take the view of anytime you can slow down movement in a certain direction, it's a good thing. Because I mean, not to be too blunt, but the other side learned in a very stark sense that if they keep pushing, eventually something might happen that might give them an in. And the reality is that none of us know what the court is going to be doing next week, next month, next year, what it's going to look like, who's going to be on it. And because of that, anytime, and I think you literally saw that in some of the responses from the right with Justice Barrett's recusal in the charter school case. There were a lot of people that day. I mean, first of all, some of them should have known because she had already been recused. She wasn't at the argument. But maybe just wanting to make a thing of it. There were a lot of right-wing attacks on Barrett that day for having recused, because they do understand that with 9 justices, you need to act when you can. And so I think anytime that that whether or not Alliance Defending Freedom is going to push for the most grand interpretation of a case that they can, we know they're going to do that regardless of what happens. But if you can have a Sotomayor opinion, or you can have a 4-4 decision that doesn't move the court at all, that is for now a win. And I think, like, I'm sure we're going to get more into the charter school case, but I think it is interesting to think about which conservative justice was it who sided with the Democratic appointees, and like, if it is Chief Justice Roberts, that's all the more interesting, because he is the justice who wrote most of the decisions in recent years expanding the law in that direction. So if I forget if it was Dena or Alison who said, like, there's some pause somewhere on the court, and I think that could be a sign that maybe Chief Justice Roberts wonders if the court has gotten a little ahead of itself on this.
Yeah, and I mean, a practical implication is that, I don't know of, and I'm pretty sure I would know, that there's no other challenge yet to bring this charter school issue back in front of the courts, right? They were putting all their eggs in one basket. It didn't work out, but the president, I watched last week the President's Religious Liberty Commission meeting, where several advocates were gung-ho about the next attempt, right? Like they're looking forward to it. They hope that it happens soon, but it can't happen like it's unlikely to happen next term,
Right.
because you have to apply to be a charter school, get it approved or disapproved, and then bring the case in the lower, like it's going to take time. And so that is like a very practical implication of one of these decisions, that we hopefully don't have to deal with this for at least another year. But
I mean, I'll always add the caveat of they can make a lot happen quickly on the shadow docket when they want to. But I mean, you're right as to like, are we going to get a merits case? Like it's not going to happen. And because it is state law, it's harder to get it onto the shadow docket. But I always get a little nervous when we get too certain that there's not going to be a case quickly, because
I mean, look at the COVID. Look what happened with COVID, right? I mean, that was after Justice Barrett was on, and it was sort of, as you were saying, Justice Robert, who was sort of on the side to maintain some restrictions on religious exemptions when it came to COVID, and then after Justice Barrett, sort of the shadow docket, they sort of pushed right through that, right?
Yeah, absolutely. Well, I want to pivot just slightly to a different case. I want to talk about Mahmoud v. Taylor, which has not been decided yet, but we're certainly getting the decision tomorrow. And I don't think it's going to be an example of an exercise in judicial restraint. This case in particular raises major questions about the rights of parents with religious objections in public schools, asking whether requiring children to attend instruction on gender and sexuality without parental notice or an opt-out ability burdens the parent's religious exercise. So I want to ask y'all, how do you interpret this case in the broader debate over religious liberty? And what do you think the implications are, once more, for the free exercise clause, but also for public education?
Well, I'll go ahead and start and say that conservatives have been trying to establish stronger protections for parental rights under the First Amendment for some time. It's been a real push to sort of assert parental rights as like a really core aspect of the First Amendment, and to align that under that provides like basic strict scrutiny oversight of what the government does. So it's been really important to them as like a project, and this is a way for them to sort of further this project in a really significant step. So it's a very important case. For years, of course, there's been a recognition of a right to direct the religious upbringing of one's child. That's a recognized right. However, parental rights under the free exercise clause, there's been the court has long understood there's some level of restrictions on them. They're not unlimited, right? There's other sort of considerations in play, and so what I think might happen, I hope it doesn't, is that they might sort of push those aside and say that this is actually a really strong right, and it's basically it can be enforced in a broad way. But I'll pass to Chris and Dena.
Yeah, I mean, this was, I think that this is a case that what we actually get tomorrow is going to be dependent on who writes it. I think that if Alito writes this, it could be a very, very bad decision. I think if Kavanaugh writes it, it will probably be a little more narrow. He seemed more concerned that it was the school district where he had grown up in than it was any legal issue. But that might work in our favor. Focus on that. I mean, I do think that the best news for wanting this to be a narrow decision is that I don't, if this is kept very much to the facts of the case, I don't think it comes up all that often. But if it is, if like Alito's allowed to get a hold of it and actually keeps a majority, I think you could end up with something that tries to do exactly what Alison was just saying, and really push this as far as it can go.
I'm just going to make a little joke about facts in religion law cases. We saw what happened 3 years ago now, in the Coach Kennedy case, where they kind of made up their own facts. But, Jamaal, your question about what are the broader implications, one thing that came to mind when you asked that question was kind of just how anti-public school groups have been creating false controversies about books and curriculum and policies for years. And those are intended to sow distrust in the public schools. So Alison is exactly right about parental rights and like trying to move the law, but there's like a bigger narrative, I think, going on. They're pushing laws and policies to directly or indirectly, in this case, like through opt-outs, ban books, stand in the way of public schools teaching lessons about race or sexual orientation and gender identity. They want to encourage teachers to pray with public school students. They want to require the display of the 10 Commandments. And a lot of these arguments for these policies are rooted in religious freedom and the mistelling of our nation's history and traditions. And as I said, it's a part of the effort to undermine public schools, which is a way to push for the religious public charter school that we just talked about, or even private school vouchers. And it essentially, kind of a unifying theme is that they're using the government to impose religion on all the children, whether it's in the public school context, as we just talked about, or in the private, allowing private schools to get taxpayer funds through vouchers. And it's a consequence of the erosion of the perceived strength of the Establishment Clause.
And I think that it is very ironic that we are probably going to get a concerning decision tomorrow related to that, and it's going to talk a lot about parental rights, I'm guessing. But the question of parental rights didn't come up in their Skeretti decision. So for those who aren't familiar, last week, the conservative justices delivered a very devastating blow in their decision in Skeretti, which upheld Tennessee's ban on gender-affirming care for transgender youth. More than half the states in the US have already passed similar bans. So it's really hard for transgender young people and their families to get the care that they need. But with this decision, they once again, I see a lot of irony in it, because this is another decision where they won. All of a sudden, parental rights are not, the primary focus, but also there was this assertion that we could leave it up to the democratic processes, the same democratic processes that the court has undermined over some time. So I just want to, talk about the Skeretti case and what you think are some of the immediate and long-term implications of this decision, and also perhaps in a broader context, discussing how this term's decision in Skeretti, in what we assume to be Mahmoud v. Taylor, will affect state and local governments going forward and legislation around these topics moving forward.
Well, I do think it's interesting. I mean, the fact is that the court didn't grant cert in Skeretti on the parental rights issue, and both of those petitions are technically still before the court. They were conferenced at their last conference, and that's both the Tennessee law and the Kentucky law, because the private plaintiffs who sued the parents and trans children who were part of the lawsuits did raise parental rights claims. The case that the court granted was DOJ's petition for the Biden administration, and it only brought the equal protection claim. So what we could see is some very weird happenings over the next weeks if they do GVR, grant, vacate, remand those two cases and say to reconsider them in light of Skeretti and essentially re-look at parental rights. But the fact of the matter is, the way that the Supreme Court decided Skeretti, it did leave that question out there. It also left out there the question of what happens with a case where you actually show animus And it also left out the ultimate decision of what level of scrutiny applies to gender identity-based claims, transgender status-based claims, because the court in Skeretti decided somehow that the ban on gender affirming medical care for trans minors was not a transgender status based ban. And so while Skeretti was like a really bad decision for its effect, it was also just a really poorly done legal decision that didn't resolve half of the questions that people thought these cases would be resolving when they went up to the Supreme Court. And in light of what we were talking about, that any time that you take to resolve something is a win, that's sort of a good thing, I think, for people who want the court to do good things for trans people. Not deciding is a win for right now.
I agree with Chris 100%. It was a, devastating decision, but it did leave open several really important avenues for fighting for trans people, for trans children, for medical access. And, I know that advocates are going to continue to fight to make sure that people can access the care they need for trans youth and for trans adults across the country.
So what role do you think continued advocacy and public education will play in shaping public opinion and potentially influencing future legal or legislative efforts on this issue?
Can you repeat that? What role? Sorry.
Yeah, what role do you think continued advocacy and public education will play in shaping not just public opinion, but also, influencing future legal or legislative efforts on this issue?
I mean, I hate to speak up again, but if nobody else wants to, I mean, I think that a great example is what we saw in the charter school case, that you had sort of this odd situation with a conservative Republican Attorney General, Gunter Drummond in Oklahoma, who was not making the arguments that I think any of us on this Zoom would be making for why the allowing the charter school was bad. He sort of every press release that he issued, sort of the first paragraph was this great paragraph about not wanting religious schools. And then the next paragraph was this fear of Sharia law entering the school system. But I do think that him having that argument up there did matter, because there was this idea that sort of dovetails really well with Justice Sotomayor's decision in the Wisconsin case about religious neutrality, that might have been enough to give one justice who is a Republican appointee pause and say, I don't want to open the door to every religion demanding a need for public school funding, and that might not be enough once we get all 9 justices, but it might have been enough to get one justice now. So I think being aware of the fact that the arguments that you as an advocate might want to make might not be the argument that is really important to getting a majority of this court to side with you is an important thing to always remember right now.
I would add that, for now, it might seem like, conservatives, Christian nationalists have control of the courts, and especially the Supreme Court at this moment. I think that the reason that they're so eager to consolidate power and push through these cases is because they see the writing on the wall when it comes to demographics, that every day we're becoming more and more religiously pluralistic society. There's more people that are non-religious, that are religious minorities. And, the changes that they're trying to impose, they impact average people's daily lives. Like if what your child is able to learn in school and whether the books they need to learn from are going to be banned is going to affect parents. They care about that a lot, right? And so those types of that sort of overreach impacts people. And so, our voices are important, and as it affects more and more people, I think over time, we can't maintain this sort of legal Christian hegemony over the law. I think it will fray, especially as demographics continue to change. And I think that's really important that we all continue to speak out about that.
Right. I think that in the charter school case, the charter school community who had kind of stayed on the sidelines in the Oklahoma Supreme Court came out in force in the Supreme Court and just made sure that people knew that it affected the whole charter school movement, which, is a bit of a conservative experiment in getting around the public school system. And, Alison's right. Like how many people will lose their unemployment insurance benefits after the Wisconsin case? How many families won't be able to see themselves reflected in books and discussions in the classroom anymore, right? It is affecting a lot of people across the sort of the public square, right? From public schools to the workplace. And, it's really important that we keep talking about the effects of this and who is harmed.
Yeah, absolutely. So the court has had a ton of decision that has expanded the free exercise clause, and they've been primarily for Christian litigants. With the increased push for things like personhood laws, do you think religious arguments against it, for example, Judaism and Islam do not believe in personhood at conception, do you think those kind of arguments will have any sway?
I think that those have come up in some of the abortion ban cases at the state level or at the district court level. And I feel like only one case has ruled on that issue. Alison and Chris, correct me if I'm wrong. So it hasn't been, I don't know that it's gotten a lot of traction. But, I think that thinking creatively about all the arguments you can make is really important.
I will say this Supreme Court has been, let's say, inconsistent on how they treat people of non-Christian religions. There was a case about prisons and a death row inmate several years ago who I think had a Muslim a religious leader that wanted to pray with them before they died, and the Supreme Court says, no, you don't have to do that. It's not allowable. But the term after, it came up with a Christian minister who wanted to do the same thing, and the Supreme Court suddenly flipped and had the opposite opinion. So it's kind of interesting. Sometimes it has to be through sort of a Christian lens before they realize there's a real religious freedom issue here. So it's kind of hard to guess at how this would play out in the long run and how it would come up in terms of personhood.
Yeah, I think any of those arguments really face an uphill battle at the court, and particularly using it in that way. I definitely agree with the idea that, like, thinking creatively, trying creatively, you never know what's going to work, what's going to slow things down, what's going to get somebody thinking about things in a different way. So I definitely would not discourage it. But I would also be surprised to see much success on that framing.
So just in reflecting on some of the Supreme Court's religious liberty cases this term, what type of religious liberty cases do you anticipate the court will be asked to consider in the coming years, or maybe even next term? I know someone in the comments specifically asked about their thoughts on requiring the 10 Commandments being displayed in public schools. And so I assume that would be something that could potentially come up. And what else do y'all think we could be expecting?
Well, there's 3 that have already been sort of accepted for cert. The first is First Choice Women's Resource Center v. Platkin, which is about New Jersey's investigation of a so-called crisis pregnancy center, or sort of a deceptive anti-abortion center. And that's about an investigation and a process one. So I'm not sure if that involves religious issues directly, but it's certainly implicated. The second one I would mention is Chile v. Salazar, which is about bans on anti-LGBTQ conversion therapy. And that, again, is based in free speech, but there certainly has religious freedom elements there as well. And the last one is Landor v. Louisiana Department of Corrections, which is we call it RLUIPA, Religious Land Use and Institutionalized Persons Protection Act, I believe. And that's about damages for a Rastafarian prisoner whose hair was shaved by the Department of Corrections. Mm-hmm. So that's another case. And that's sort of similar to a case from a few years ago called Tanvir v. Tanzan. But I'll see if either of you want to add anything further on those.
Well, go ahead, Chris.
I just think the fact that they took up the conversion therapy case after rejecting several of them is a very alarming sign, and it's also fits in with what we've discussed about the efforts to move quickly while they have the votes.
Yeah, and back to the 10 Commandments point, on Friday. Was it just Friday last week? Yeah. The Fifth Circuit panel decided that the Louisiana law requiring the display of the 10 Commandments in every public school classroom should be, the injunction should remain in place, and the law should not go into effect. And, back to the discussion we had earlier about what does it look like when there are good decisions. This was another good decision on the Establishment Clause. It was a very sound reasoning. They ruled strongly in favor of the plaintiffs, who were families with school children and religious leaders. So that is not to say that things won't change, but there is, to see, the Oklahoma Supreme Court, the Oklahoma Attorney General, and now this Fifth Circuit panel to really embrace the Establishment Clause protections and how important they are, especially in our public schools, is refreshing, I guess.
Absolutely, especially because there's Supreme Court precedent directly on point, almost exactly the same law in a case called Stone v. Graham. Yeah, it's excellent.
But that's not to say that it won't be, how fast will, I think that they're going to petition for an en banc rehearing, and how fast it could get to the court. And there's a similar lawsuit in Arkansas, and Texas also signed a 10 Commandments display law into place. So it will remain on people's minds and be moving through the courts. So
it goes with obviously a good decision, but it should be noted that was a more rare 2 Democratic member panel of the Fifth Circuit, appointee panel of the Fifth Circuit, and the one Republican appointee was one of the what passes now for one of the more reasonable members of the Fifth Circuit Republican appointees. So I am actually a little nervous about what happens with that en banc petition.
Yeah. So you all are so incredibly informed about the law in these areas and are doing the work to advocate, to educate, and to bring awareness around these issues. How are progressive advocates, religious minorities, and civil liberties groups, how are they going to look at and prepare for what's next? And what strategies do you believe are most effective in this legal climate?
Well, one thing that we're doing, and we encourage other groups to get involved with, is to look at who is being appointed to the courts. Right, to the President Trump is on his, I think, second wave of judicial nominees. There's been 2 waves, and there was just a hearing yesterday on some judicial nominees and a vote today for the first round of judicial nominees. And he's putting forward some truly extreme loyalists, people that are dedicated to Trump above the Constitution. And so it's really important as advocates, whether you're individual or with part of a group, to get involved, to speak to your senators and tell them that you demand members of the court, judges who are fair, who are fair-minded, who support equal justice for everybody, and who are going to uphold all of our civil rights. And that's really essential. So doing what we can to stop these nominees who are not qualified. And, there's different things we mean by not qualified. We don't just mean, oh, you've clerked for several people, but you have to be qualified. You also have to understand civil rights and support them. You have to be a fair judge, right? You can't just be dedicated to upholding the president. That's a matter of qualification. So we should not consider anybody who is to be qualified if they're not willing to uphold the Constitution and the rule of law and put that first. So I'll stop there, but it's what we work on. We work on all the time. So it's really critical that we all stand together and oppose really terrible judicial nominations.
Absolutely.
Yeah, and I think that another really important thing to do is some organizing and educating, because the separation of church and state is actually it polls well. It's a popular, fundamental value that we all hold and understand. And so we just need to make sure that, people are willing to stand up for that, and demonstrate that the continued erosion is kind of against popular opinion. The courts don't really tend not to, I should say, go where they don't have public support. And, to Alison's point earlier, we are a ever more pluralistic society, and, the continued imposition of religion by the courts and by government on people is less and less popular. And we just need to kind of find ways to communicate that really well and really strongly.
I would just add, echo both of those, but then just add also to be paying attention to state and local developments as well. That there are, I think, what we saw particularly like 3 years ago at this time around the overturning of Roe versus Wade, that there are a lot of opportunities for action within state courts, within state legislatures that might be able to do the work that Dena was just talking about with a slightly more accessible legislature, a slightly more accessible court. Even sometimes there have been some really good court rulings that we've gotten in what might to somebody just thinking about it writ large think are surprising states, but those state constitutions sometimes have protections that we can really use to our benefit when the Supreme Court isn't upholding the protections that we know are there, but they're just not prioritizing in the same way anymore.
Yeah, thank you all for that. You kind of actually got into my follow-up question for that, which I was going to ask, what role can advocates and lawmakers and everyday people play in defending church-state separation? But instead, I think it'd be helpful to kind of put you all on the spot as a brief motivational speaker and end on a note of resilience. And maybe what would you say to viewers feeling disillusioned or frustrated by the direction of the Supreme Court?
I'll give the simplest answer is it's 9 people and they can change at any time. The court, what it's doing today is not what it will be forever. And you don't need to take my word for it. Like, just watch Justice Jackson's dissent. I think we are seeing a justice really coming into her own with an awareness of the fact that maybe ironically learned from Justice Thomas that it's okay to be the sole dissent, because sometime in 10, 15, 20 years, you might be writing the majority decision. And I think we're seeing from her some realization that is the role she is playing right now.
I think that's right. And also, you know, Justice Jackson prior to this served on a lower court, right, where she was developing those skills as a judge. And so it's important to get involved in politics. You can get involved even as a judge if you're a lawyer in some places. You can, for example, support when we put forward good judges, and work to oppose some of the bad ones, but really make an effort to sort of put yourself forward if you happen to be a lawyer and are able to sort of become a judge. That's one avenue. And others, just build for the future. Like, in order to be successful in the long run, we're going to need some of these arguments, some of the legal arguments that will allow us to sort of push through some of the resistance and some of the arguments that are coming from the other side. I mean, what we're seeing, as Chris mentioned, is not just Thomas's sort of fringe dissents over 30 years. That was the basis by which a whole movement built on over time through law articles and through development and through conferences. And so we need to make sure that we're taking the effort to build an alternative view that supports equal rights and civil rights for everybody, and to continue to make an effort to advance theories that benefit us all and not just a select few.
Yes to all that. But what can people do kind of in their communities? Kind of what Chris mentioned a minute ago, which is pay attention to what's going on at your school board. Pay attention to what's going on at your city council, your town council, or your county council. Pay attention to what's going on in the state legislature. It doesn't take that many voices to stop things in these places or advance good policies, right?
Yeah.
I'm frequently, I'm trying to think about how to stop the 10 Commandments bills or chaplains in public school bills, right? Like, I think about that a lot. But the flip side is equally true, that we can advance good protective policies. And talk to your friends and neighbors. And if you talk to the people you go to coffee with, talk to the people at your church, your synagogue, about why we need to have religious freedom that supports everyone. It underpins so many other rights. We can't have full access to reproductive health care or LGBTQ plus civil rights if there are giant loopholes that are in place for religious exemptions. And it allowed religious freedom, the separation of church and state, allows everyone to believe as they choose, live as themselves. And it's what ensures that we're treated equally, because no one is treated differently because of their beliefs. And the more people are talking about it, and it's easy to do, the better off we're going to be.
Sure. Wow. Well, I would like to once again thank you. Thank you, Alison. Thank you, Chris. And thank you, Dena, for breaking down the 2024-2025 Supreme Court term with me, giving us incredible insight into these cases, what we can expect, how we can counter it, and how to understand them. The Supreme Court's conservative majority is rapidly issuing decisions that are rolling back longstanding rights. Their last decision day will be tomorrow. And I think that we've learned from this panel that staying informed is essential. It's the first step in mobilizing and pushing back against some of these sweeping, inequitable changes. So, to continue to stay informed, especially for those decisions we're waiting on, subscribe to Law Dork by Chris Geidner. Check out Americans United for Separation of Church and State and the National Women's Law Center's websites. Links will be included in our follow-up email. Additionally, please follow Alliance for Justice on social media to stay up to date on the Supreme Court and future events like these. Although the Supreme Court term is nearly over, AFJ works year-long to keep tabs on key updates related to both federal and state courts, as well as following and providing research on Trump's judicial nominees. You can learn more about AFJ's work at afj.org. We appreciate you for tuning in today. I want to thank our panelists again for taking the time to educate us today. And we can't wait to see you all next time.
Thank you
so much.
Thank you.